Being sued by a creditor or debt collector could be nerve-wracking. Now, if you have been recently served a subpoena or court order regarding a debt that you may or may not owe, you probably want to watch this video to the very end so that you can know what to expect. What's up, thinkers? Chris Robinson here, reminding you guys to like the video to show your support. Also, don't forget to subscribe so that you can stay in the loop of similar videos like this. Enough talking. Let's jump into the details. Okay, so the first thing I want to talk about is verifying the source of this debt and the timeline from when you first started receiving communications from this creditor or debt collection agency. Also, I would like to explain what should have happened if you have started receiving this communication already, or if you have not experienced this yet, you probably want to take notes on what to expect. Now, here's the timeline of what you may have experienced or what you should expect if contacted by a debt collector. So, the first step or the first event, you should receive a phone call or a letter in the mail from the debt collector notifying you that the debt is in collections. And this typically occurs when a debt is 180 days past due. The second step or second event within this timeline is that within the first 5 days of being contacted, the debt collector must send you a debt validation letter stating how much you owe, the name of the collector, and how to dispute the debt if you believe that it's not yours. Now, within the third step or third event within this timeline, if you don't believe this debt belongs to you, you can ask the debt collector for a verification letter. And they must send this letter within 30 days of the validation notice. Now, just to backtrack a bit, if you have not received a validation letter from the first initial contact, then you must first send that validation letter to the debt collectors first. And that must be within 30 days from when they first claim that you are being in collections. Okay, so step 4, or within the fourth event of the timeline, if your debt is legitimate, you must respond to the debt collectors and create a plan for paying off the debt. This can mean paying the debt in full, or setting up a payment plan, or negotiate the debt. Now, the following step, or the fifth event within this timeline, is that if you do not repay or settle the debt collector could sue you. And at this point, you'll probably be served a notice from the court regarding your appearance date. And if you make it to the sixth event of this timeline and you fail to show up to your court appearance, the court will most likely rule in favor of the debt collector, which will lead to the seventh event of this timeline, which is called a default judgment, which is not a good thing because this means that your wages can be garnished or a lien can be placed on your property. And typically within 20 days of this ruling, that means that they will start garnishing your paychecks right away or place a hold on your property in order to confiscate. And after knowing all that, if the debt begins to the point of reaching a lawsuit, it is important and essential that you respond to that lawsuit, because responding to the lawsuit is the most important thing if you don't want your paychecks to be garnished or if you don't want your personal assets to be seized, and this can even be a home if you own one. So this is exactly what you need to do, and this can be done in primarily 2 different ways. So the first way will be to contact the debt collector and try to reach a settled agreement before the court hearing. Or you can simply just attend the court hearing, especially if you believe the debt is not legitimate. Now, if you're wondering why would anybody attend that court hearing, like I said, if it's not legitimate, you probably most likely want to attend this court hearing if they do not want to remove it. Now, what is the most common ways people would attend a court hearing? I mean, there are many different reasons why people will attend the court hearing rather than settling, especially like we said, if it's not legitimate. However, some of the most common reasons are related to them having the wrong person, you already paid the debt amount is incorrect, or the statute of limitation has passed, which is different by each state. Now, if you're still with me in this part of the video, you're probably wondering how you can actually challenge this lawsuit, right? Okay, so if you're being sued by a debt collector and you disagree with any or all of the information within that lawsuit, you could file a response to the lawsuit within the court. And during this court hearing, you will have the opportunity to refute any of the information that you disagree with, or you can ask the court to get rid of it altogether. I know it sounds simple, however, it's not that simple because you will have to bring some evidence or proof to represent your case. Now, if you did send a validation letter, this can also show proof in the court because the letter will show who the collector is, whether the debt has been paid, whether the amount of the debt is accurate, whether the debt is past the statute of limitation. Also, if you was on your P's and Q's from the beginning of the process, you will also want to bring evidence of collection collection violations. And what I mean by that is that if your rights have been violated by the debt collector, you must bring that evidence to the court. And this means that you have to do your homework and be familiar with things like the Fair Debt Collection Practice Act, the Fair Credit Reporting Act, and the Truth in Lending Act so that you can identify those violations. And just to give you a few examples, under the Fair Debt Collection Practice Act, debt collectors may not contact you outside of the hours of 8 a.m. to 9 p.m. They can also not engage in harassment, which could include anything from using profanity to threaten harm. They cannot partake in unfair practices like threatening to take your property when they do not have the legal right to, or depositing a post-dated check early. They can also not contact you directly once you have already been represented by an attorney, and they cannot make fraudulent claims such as misrepresenting who they are or lie about how much you owe. Alright guys, so that's my cue to conclude this video. If you found the information of this video helpful, be sure to smash the like button if you haven't already. Also, be sure to watch the suggested video because YouTube think you may be interested in it. Otherwise, I'll see you guys in the next video. Peace.